Hi everyone, and welcome to another tutorial in administrative law. So today we get to talk about grounds for judicial review. But before I proceed, I would like to pass three paramount announcements. The first announcement is, before you start listening to this tutorial, go back to the first two tutorials in which we introduced what judicial review is, and the second tutorial in which we talked about the grounds for judicial review as well as legitimate expectation and its full notion. The other announcement is, if you don't want to be left out on any future uploads, subscribe to this channel, because only those who are subscribed to this channel will receive a notification with regards to our future uploads. The other announcement is, if you want us to talk about a certain topic which is of your interest, feel free to comment below and then we'll consider your comment, and in the future day we'll get to talk about that very topic which you really want us to talk about. So today I proceed and we'll be looking at grounds for judicial review. So basically, the inherent power of the court to review the actions of administrative agencies is based on the allegation that the agency has usurped, exceeded, or abused its powers, or even failed to comply with its public duties. The court is required to measure what has been done or ought to be done against the relevant statutory provisions interpreted in accordance with the appropriate presumptions of legislative intent. Therefore, administrative action is subject to control by judicial review under three heads, which are illegality, irrationality, and procedural impropriety. Well, this does not really mean that in any way there are no other grounds coming up. For instance, the ground of proportionality is recent and is only recognized by the European Economic Community. So let's get to talk about the three grounds of judicial review. And the first one is illegality. So basically, an administrative decision is flawed if it is illegal. A decision is illegal if 1. It contravenes or exceeds the terms of the power which authorizes the making of the decision. 2. It pursues an objective other than which the power to make the decision was conferred. Therefore, under illegality, this is where the decision-making authority has been guilty of an error of law, for example, by purporting to exercise a power it does not possess. Thus, the decision maker must not misunderstand or misapply the appropriate law. So, by illegality, as Lord Diplock put it in the case of Council of Civil Service Unions and others versus Minister for Civil Service, illegality as a ground for judicial review was stated to mean that the decision maker must understand correctly the law that regulates his decision-making power and must give effect to it. The nature of illegality is a primary ground for judicial review of administrative decisions. It is constituted by a public body consciously exceeding its power, its express or implied statutory or de facto powers, or misconstruing the extent of its duties. Basically, evidence of dishonest conduct, bad faith, or merely innocent misconstruing of matters of law, procedural irregularities, contravening the mandatory provisions, or unreasonableness which towards the policy behind legislation have all been described as illegality through, although they can also be brought within other categories of grounds for judicial review, which we'll look into. So allegations of illegality are common in cases where the extent of statutory discretion is an issue. The court cannot determine the rights to exercise a discretionary power. It can only indicate the parameters of the powers. So for you to understand clearly how the court exercises or uses judicial review as a mode of ascertaining whether a public body was functioning its statutory conferred authority in a right manner, I would recommend that you go back to the first tutorial. It talks about judicial review and the processes and the effects, how the court uses judicial review to ascertain or assess the actions of a public body. So the second ground of judicial review is irrationality. So irrationality is a ground used in judicial review proceedings for challenging the quality of a decision by reference to the reasoning behind it. So they make reference to the reasoning behind it. So the decision maker's decisions must not be vitiated by irrationality, where the decision of outrageously absurd or utterly illogical or perversely defies accepted standards to such an extent that no rational person could have taken it. So basically, that is the whole notion behind irrationality. Cases where the courts are called upon to adjudicate on the rationality of administrative action most frequently arise where public authorities are given by statute wide powers to act according to their own discretion and are not bound by detailed rules. Irrationality is also known as the Wensbury unreasonableness, after the case of Associated Provincial Picture House Limited versus Wensbury Corp. So in this case, it is stated that a decision would be unreasonable if it is so unreasonable that no reasonable authority could ever have come to it. By irrationality, as Lord Diplock put it in the case of Council of Civil Service Unions and others versus Minister for Civil Service, irrationality means that by irrationality, the court stated that it means can be now be sanctically referred to as Wensbury unreasonableness. So it basically applies to a decision which is so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. So basically, the court and Lord Diplock in the case of Council of Civil Service Unions and others versus Minister for Civil Service mentioned that irrationality basically implies a decision which is so outrageous in its defiance of logic or of accepted moral standard that no sensible person who had applied this mind to the question to be decided could have arrived at it. So they looked at whether the decision made by a public body or a person occupying that public body in exercising its functions came to a decision or a conclusion which is so unreasonable such that no any other person in his position would have come to that particular conclusion. So probably the most difficulty Wensbury principle relates to acting reasonably, as this is where there may be temptation for the courts to substitute their own values for those of the decisional maker. It has been held that the fairness and reasonableness are objective concepts, otherwise there would be no public law. So it is now well established that the Wensbury principle itself constitutes a sliding scale of review, more or less intrusive according to the nature and gravity of what is at stake. This can be observed in the case of this assertion can be observed in the case of R versus Secretary of State for Education and Employment ex parte bed B. So the concept of a decision being so unreasonable that no reasonable authority could have come to it is necessarily difficult to define. The court have to decide whether a reasonable tribunal could have come to a particular decision, not whether the decision is is reasonable. The concept of unreasonable has, despite its rhetoric, not been confined to cases where the decision in question is totally arbitrary, but has been used to justify judicial interference on the basis of burdens being placed upon the owners of property rights, even where the court has disagreed with public bodies' assessment of how much weight ought to be attached to a particular consideration. So in the People versus Attorney General ex parte Derek Chitala, the applicant applied for certiorari to remove into High Court for purposes of quashing the decision by the President and his cabinet to have the next constitution enacted by Parliament. One of the grounds advanced in support of the application was the decision was unreasonable in that it was contrary to the recommendations of the Constitution Commission, and based on the totality of the evidence before the Commission, there was no evidence to support the government's decision to have the Constitution enacted by Parliament. So in this case, it was held that although the application was neither frivolous nor vexatious, it was legally an attainable application on the face of it, such that it was not wrong for the judge below to refuse leave summarily. This was because after a perusal of the relevant documents, the Supreme Court considered that the arguments did not support that there was an issue of irrationality fit to go to a full hearing. So under the heading of irrationality are encompassed the following grounds. So there's one, decisions taken in bad faith. There is decisions made with consideration of irrelevant matters, including fettering of discretion by adopting rigid rules of policy or by agreement or improper delegation. The third heading under rationality is decisions made taking into account irrelevant matters. The fourth one is decisions where no reasonable authority could come to. And the fifth decision is where regard to procedural requirements, including the rules of natural justice. So these heads, if any of these heading of irrationality are observed in a certain decision, then one can use irrationality to claim using judicial review. So the next ground for judicial review is procedural impropriety. The decision maker must not be vitiated by procedural impropriety. In other words, the public authority must act in accordance with the correct procedure. A public body will be open to challenge where it has acted unfairly towards the applicant by failing to observe basic rules of natural justice or failing to act with procedural fairness, even where an applicant has not been denied natural justice. There may be good challenge where the body has failed to observe procedural rules expressly laid down by statute or delegated legislation. So by procedural impropriety, as Lord Diplock put it in the case of Council of Civil Service Unions and others versus Minister for Civil Service, Lord Diplock described procedural impropriety as failure to observe basic rules of natural justice or failure to act with procedural fairness towards the person who will be affected by the decision. In many situations, Parliament has provided that certain procedures must be followed by an authority in exercising its powers, and by the citizen when the citizen uses the administrative machinery of the modern state. So if Parliament has not laid down statutory procedural rules, the courts may infer that long accepted common law standards of fair procedure shall apply. So in a situation where no statutory procedure is laid down, then the courts may infer that long accepted common law standards or fair procedure shall imply. These common law procedures are usually referred to as the right to fair hearing. So under the heading of procedural impropriety are encompassed the following grounds, just like irrationality. So the first one under the heading of procedural impropriety is the decision made was biased. Secondly is the decision made failed to provide a fair hearing, and the third, the decision maker failed to provide reasons for the decision after it was taken. So if any of this was to be observed in a decision making process or a decision made by a public body or a person occupying a public body, then one can use procedural impropriety as a ground for judicial review. Let's go to another ground. So the other ground is proportionality. So continental courts have developed a doctrine of proportionality, that the administrative decision or action must not be out of or proportion to the circumstances of the case. In general, this doctrine has not been recognized in English administrative law, although in the case of Council of Civil Service Union case, the Lord Diplock spoke of the possible adoption in the future of the proportionality principle, which is recognized in the administrative law of several of our fellow members of the European Economic Community. So the nearest English courts have come to this doctrine is in the case of R versus Barnsley Metropolitan Borough Council ex parte Hook, where the punishment imposed on a storeholder for having urinated in public and cheated the market superintendent was described by Lord Daning as too severe punishment. So the principle of proportionality in essence basically means that there must be a proportionate relationship between the objective which is being sought to be achieved by a public authority and the method used by the public authority to achieve that objective. So that is what is behind the whole principle of proportionality. Proportionality is relied on or asserted when an individual considers that an administrative decision is harsh or excess in comparison with what should have happened. So for proportionate to be an appropriate means of challenge, the public authority must have the power to act. There must be no error of law. The correct procedure must have been followed, and most importantly, there must be open to the authority a choice of several actions, discretion to operate on a sliding scale. However, the principle of proportionality was given greater acknowledgement and support where the issue involved what were termed as constitutional, so basic or fundamental rights. The more substantial interference with human rights, the more the court will require by way of justification before it is satisfied that the decision is reasonable. In all these cases, the importance of the rights was directly relevant to the lawfulness of what had been done to interfere with its enjoyment. So these grounds of judicial review are the grounds that one can use to claim or use judicial review under. So basically, just to emphasize, judicial review is only available as decisions made by public bodies. So these bodies are government departments, local authorities, tribunals, the state agencies exercising powers which are governmental in nature. If judicial review is applied for, and the court rules that the body whose decision is being challenged is a private body, then the remedy will not be granted. So you can look at the cases of Ludwig Sondashi versus Godfrey Meander, in which the appellant had been expelled from the respondent political party and sought judicial review and a declaration. So in this case, you can observe that because judicial review is a mode that you can use to challenge decisions of a public body, and the body in question was not really a public body, then judicial review cannot be used in this situation. So the trial court found that the wrong procedure had been adopted, as the respondent was a society dealing with private matters and not public matters. So you can only assert those grounds of judicial review if a matter is one of a private matter, rather if a matter is of a public is made of by a public body. So with that said, I would like to remind you to subscribe to this channel and drop a comment. If you want us to keep on uploading similar tutorials, please inform us. Or if you want us to talk about this very topic more, comment below, and then we'll consider that, and then in the future day we'll get to upload or respond to your comment. I hope you've understood, but if you haven't understood, feel free to comment below, and then we'll get to post another video explaining further so that you understand thoroughly. Have a great day, and thanks for listening.